Hi everyone, this is Antonio, and in today's video we're going to discuss attorney-client privilege and other testimonial privileges. So let's start by giving a definition of attorney-client privilege, which is protecting any communication between an attorney and a client intended by the client to be confidential and made in an effort to facilitate professional legal services. So let's break it down and let's analyze each element one by one. So it has to be intended to be confidential, which means that, for example, if the conversation took place in a public area where other people could have listened, then the conversation was not intended to be confidential in the first place, and this means that the attorney-client privilege would not protect the conversation. It has to be made to facilitate professional legal services, so not any conversation between the attorney and the client is protected, but just the conversation that is made to facilitate professional legal services. It has to be between a client and an attorney, meaning that also representatives of the client or the attorney work just fine. So, for example, if the conversation is between a client and a paralegal, would be protected by the attorney-client privilege nonetheless, even though, of course, the paralegal is not an attorney. Okay, and who is the holder of the privilege? The holder of the privilege is the client, not the attorney. So the client decides whether he wants to keep the privilege, hold the privilege, or not. There are, of course, some exceptions to the testimonial privilege, to the attorney-client privilege, and one of the exceptions, probably the main one, is if the legal services are sought to further a crime or a fraud. In this case, the attorney-client privilege will not apply. Another exception is if there is a suit between the attorney and the client regarding the representation. Of course, in this case, the attorney-client privilege will not apply. For example, if there is a suit regarding the attorney's fees, or if there is a suit regarding malpractice, in these cases, of course, the testimonial privilege will not apply. Okay, let's go to the spousal privileges. There are two. The first one is the confidential marital communication, which protects all communications made during the course of a valid marriage and intended to be confidential between the spouses. Who is the holder of the privilege? Both spouses. So one spouse can prevent the other from testifying. And the effect of a divorce is that the conversations remain privileged even after the divorce took place, if the conversation took place during the marriage. And the second privilege, the spousal testimonial privilege, which allows a person to refuse to testify against her spouse as to anything. Not just a conversation took place during the marriage, but as to anything. Of course, there must be a legally valid marriage. So if there is a divorce, in this case, the spousal testimonial privilege will not apply, regardless of when the subject matter of the testimony took place. Okay, will be confidential. Of course, there are exceptions here, and the first exception probably is a lawsuit between the physician and the patient. But also, and this is a big exception, if the patient's physical or mental condition is at issue in the case. Finally, there is the privilege against self-incrimination, which is a privilege which it's a constitutional protection that protects against self-incrimination and applies both in civil cases and in criminal cases, meaning that the person cannot be compelled to testify against herself. Okay, thank you for watching this video, and as always, I will leave in the description below a couple of links to books that I think are useful for the study of evidence. And also, if you like this video, you may also watch my other video on hearsay. Thank you for watching, and bye everyone.